Hi, y'all are. I'm glad for you to see me today, I guarantee. This is Paul Hood, the Cajun Counselor, with another episode of my podcast, The Cajun Counselor. Laissez le bon temps rouler. Hi, y'all are. It's Paul Hood, the Cajun Counselor. And this episode should be airing right after the beginning of the year. So what I wanted to do was I wanted to start with something that I heard when I was a kid. There was a guy on television in Alexandria, Louisiana, on KALB, was the anchor, news anchor. His name was Jules Demicourt. He was known as T. Jules, and he recorded the Cajun Night Before Christmas, but also the Cajun 12 Days of Christmas. Now, I'm not going to take you through, repeating every time. I'm going to start with the 12th. But here is T. Jules' Cajun 12th Day of Christmas. On dem 12th day of Christmas, my true love she gave to me 12 shotgun shells, 11 duck decoys, 10 Purell paddles, 9 oysters stewing, 8 crabs a brewing, 7 fleur-de-lis, 6 cypress knees, and as he says, and for them last time, them 5 poux du, literally water chickens, 4 pousse café, 3 stuffed shrimp, 2 voodoo dolls, and a crawfish in a fig tree. There you go. Joyeux Noël and bonne année. Our next item is another sort of mirthful one, but there's a lot of truth in this. Today a lot of professional estate planners, eschew the idea of DIY estate planning. And as a general rule, that's a bad idea, almost for everybody. I'm not sure I would want to draft my own will. I have in the past, but I'm not sure I would want to do that. I've drafted a few. But the idea of DIY being a bad thing necessarily for the legal profession, that got crossed out years ago in England by Lord Neaves. Lord Neaves wrote the poem I'm about to regale you with, and it's the jolly testator who makes his own will. Ye lawyers who live upon litigants' fees, and who need a good many to live at your ease, grave or gay, wise or witty, whate'er your degree, plain stuff or Queen's counsel, take counsel of me. When a festive occasion your spirit unbends, you should never forget the profession's best friends. So we'll send round the wine and a light bumper fill to the jolly testator who makes his own will. He premises his wish and his purpose to save all dispute among friends when he's laid in the grave. Then he straightway proceeds more disputes to create than a long summer's day would give rise to relate. He writes and erases, he blunders and blots. He produces such puzzles and Gordian knots that a lawyer intending to frame the thing ill couldn't match the testator who writes his own will. Testators are good, but a feeling more tender springs up when I think of the feminine gender. The testatrix for me, who like Telemach's mother, unweaves at one time what she wove at another. She bequeaths, she repeats, she recalls a donation, and ends by revoking her own revocation. Still scribbling or scratching some new codicil, which you should never use, by the way. Oh, success to the woman who makes her own will. 'Tisn't easy to say, mid her varying vapors, what scraps should be deemed testamentary papers. 'Tisn't easy from those her intention to find, when perhaps she herself never knew her own mind. And there's a lot of psychological truth in that. Every step that we take, there arises fresh trouble. Is the legacy lapsed? Is it single or double? No customer brings so much grist to the mill as the wealthy old woman who makes her own will. The law decides questions of meum and tuum by kindly consenting to make the thing suum. The Aesopian fable instructively tells what becomes of the oysters and who gets the shells. The legatees starve, but the lawyers are fed. The seniors have riches, the juniors have bread. The available surplus, of course, will be nil from the worthy testators who make their own will. You better pay toll when you take to the road than attempt by a byway to reach your abode. You had better employ a conveyancer's hand, that's a will writer in England, than encounter the risk that your will shouldn't stand. From the broad beaten track, when the traveler strays, he may land in a bog or be lost in a maze, and the law, when defied, will avenge itself still on the man and the woman who make their own will. Just don't do that, y'all. Now, this is something that I started writing about years and years ago. In fact, I probably started on this even before I spoke on the initial client interview at the Georgetown University Law Center Annual Estate Planning Conference back in 1998. And the initial client interview, and I ought to probably do a whole podcast about that one. I've done webinars and lectures about it. But I'm going to concentrate on one part. And what this is what goes through the minds of an estate planning lawyer or any other professional meeting a client the first time and the client themselves. I'm going to start with the estate planner. And all of this I basically uncovered and listed through discussing the process of initial client interviews, not only with lawyers and other estate planners, but with clients themselves. So, okay, let's go back to when we first met. And it was a long process, but I gathered some thoughts, and I want to share what goes on in the minds of an estate planner in an initial client interview. First question, am I physically safe with this client? Now, I will tell you that I'm not a little guy. And when I was in a law firm seeing clients at our firm offices, I didn't think about my physical safety at all. But when you're meeting somebody for the first time as a solo, and I was in a 2 or 3 story building on the first floor that on a weekend, there's nobody there. It was a lock on the front door, but that's about it. And so physical safety I actually thought about once, not often, but it did cross my mind. Will this person make me uncomfortable? If meeting with more than one person, either scheduled or unscheduled, is this too many people to be meeting with? And you run into this sometimes in families and even spouses. Sometimes it's best to talk to each spouse individually before you see them collectively if you want the true, complete picture. Because quite often people are intimidated and don't speak up, and they don't agree necessarily with what the mouthier spouse is spewing. Am I being used or part of an agenda of this person other than estate planning? And I unfortunately had to discover and point out a couple of times where that was exactly how I was being used. Can this client pay reasonable fees to do the estate planning work that I feel he or she needs? You have some people out there who they don't value it. Even though we can demonstrate value both now and in the future. If they're not ready, then that's not a good thing. Will this client pay the reasonable fees for the work that I perform? How likely is it that this client or his or her family will sue me or attempt to drag me into a fight after the client's death or during a divorce on an involuntary, non-paying basis as a material witness? Those are never any fun. Will this client be pleased with my work or with the work of any advisor? Can I expand my services with this client into other needs, including those of companies owned by the client? How likely is it that this client will refer me to other friends or relatives? Will I run into a snag or complication that will cause the final cost of my services to be significantly higher than the quoted fee or fee range? Can I rely on this client's representations of the facts and figures? How much due diligence will I have to do? Does this client have all of his or her marbles, or at least enough to execute legally valid documents or enter into legally binding documents? And I will tell you that there were a couple of close calls in my career where people who had good sense at 10 a.m. at 4 p.m. didn't know who the President of the United States was. And that's called sundowners. And it's a real issue for the elderly. And unfortunately, if I'm lucky enough, we'll eventually get there. I'm 65. I guess that's not old, at least according to Professor Longhair. Can I fit this client into one of the standard forms or plans that I have developed? Will this client understand this reality, or should I go over that now and possibly alarm the client needlessly? Will I enjoy working with this client? Will I rue the day that I ever agreed to take on this client at the quoted rates? I normally got rid of them long before I had to rue any days, and that's really the key. And speaking of rue, on plot is making gumbo tomorrow, a chicken andouille sausage gumbo. And I went to the Kroger last night, went Krogering, and got all of the stuff that I need. So I'm looking forward to that tomorrow. What are this client's expectations regarding turnaround time and my personal availability? Will this client permit me to allow his or her work, or at least original drafts, to be prepared by the person in my office with the lowest rate scale who is competent to perform the work? That can save clients quite a bit of money. With whom may I speak during the course of doing this work? With whom should I absolutely not speak? What confidentiality issues are present with this client? Should I send mail, faxes, or electronic correspondence, emails, texts, whatever, to a particular place? Should I call prior to sending? May I leave voicemail messages, even to say that I called? Well, today everybody's got caller ID, which really, I'm just going on a quick tangent. When I was a kid during the summer, sometimes we would like to make prank phone calls. And, we'd call the grocery store, you have Prince Albert in a can, all that kind of thing. Is your refrigerator running? You better run down the street. It's running down the street, you better go get it. Will I encounter problems with the client's spouse, children, or significant others? How clear must I be that I do not represent or work for them? Well, the answer is you need to be very clear, because the ethics rules, model rule 4.3, if I recall correctly, dealing with non-clients, the lawyer has an affirmative duty. And I say this, remember, I am a retired lawyer. I haven't practiced law for over 20 years. But I obviously still care quite a bit about it and keep up with all the ethics and everything else, because that was one of my particular areas of interest as a lawyer, was the model rules. And I used to speak on ethics. I spoke on ethics, the San Francisco edition of the NYU Tax Institute in 2001. How much TLC or hand-holding will this client expect or require? Does this client understand that this can have a bearing on fees or desirability to have them as a client? I don't want any codependence. I'm very against codependency. And sometimes clients can unwittingly become codependent, and some lawyers encourage that unknowingly without understanding the ramifications. Will this client ask or pressure me to do anything that would compromise my personal integrity or even my professional license or designation? Backdating documents. In the last year or two, we've seen 2 or 3 cases that involved backdating documents. And invariably, you're going to get caught. Okay, so it just doesn't, and it's a temptation, I get it. But it's best to think about something else. Because invariably, if there is a conflict and that is a material issue, or could be, it will come out. Misleading others about the effect of documents, which obviously you should never do. Forging signatures, not following formal execution procedures. Like in Louisiana, when I was there, when I first started, we had what was called a statutory will. Got converted to being called a notarial will. And the testator had to sign at the bottom of each page. And before a notary and 2 witnesses, all of whom watched everybody sign everything, that was and is, at least the last time I looked, a notarial will. Every year in the cases, there's somebody who didn't do that. I remember one I covered in a family wealth conference. The issue was whether it was validly executed. And while there was no evidence from the witness that they didn't, the witness's testimony was, oh yeah, he'd bring a batch of documents to witness down to the boat ramp, and we'd sign them over beers in the afternoon and go fishing. And that was enough. The court said, well, we don't really need to know anything else. This is an invalidly executed will because the witnesses didn't sign or see the testator sign. And so that can be a real problem. Lying or omitting material health information on a life insurance application. How many advisors have before me has this client gone through? Why? Bobby Blue Bland sang a song, Who Will the Next Fool Be? And I always quote that song anytime somebody came to me and said, I'm so glad I got you. I was with, I had this person and this person. And if I know those 2 people to be competent lawyers, I'm going to think long and hard about taking this person on. I'm going to have to investigate. I'm going to have to figure that out because I don't want to be Bobby Blue Bland's next fool. Will this client present problems that I lack the confidence and competence to handle? Would they allow me to bring in help? Should I discuss this candidly up front? Or will this needlessly alert the client that they should perhaps choose another advisor? I've always believed in transparency. I always told clients, if you have anything international, I can't deal with that. International is like business valuation. You either do a lot of it or none of it. And international, inbound, outbound, I didn't need to know anything about it. And I decided not to do that. Now let's go to the client. What goes through the client's mind? And the first question really says it all. Can this person help me or us? And that actually surprises some advisors when I tell them that. But that's essentially it in the initial client interview. They're trying to figure out if you can actually help them. And so you need to speak to that question because it's right in the fore of their mind. Will I be able to work with this person? Am I physically safe with this person? Will this person make me feel uncomfortable? We have some mutual thoughts. We encountered those last 2 questions or thoughts and the advisor or the estate planner. Is this person going to be loyal to me? Will this person take the time to talk to me, not down to me? And that can be a real problem, particularly for lawyers. Can this person explain the issues and considerations to me and my family? Is this going to offend any of my loved ones or hurt any feelings? Very common fear for blended family clients, who almost feel like they're pushed between their new spouse, who is not the parent of their children, and their own children. Does this person understand that for me, some of these decisions are going to be very trying? And we have to be empathetic there. There are tough decisions that people have to make. Will this person be perceptive enough to pick up what I do not or cannot express clearly or directly? Will this person even make an effort in that regard? Is this person going to take advantage of me, either on a fee or work basis? What is really in it for this person? What is this going to cost me? How long will this take? Will this person respect my feelings and desires, not try to take over just to save me taxes? And that's unfortunately what a lot of estate planners do. Because talking about taxes is much more comfortable than talking about the family dynamics. I've always been more motivated by the family dynamics part of it, which is why I'm such a human side of estate planning kind of guy. Can I call this person whenever I want? If not, when may I call this person? May I call this person at home, on weekends, after hours, on their cell phones? Will this person return my calls in timely fashion? Are our definitions of timely aligned? Will this person keep my affairs confidential? Will this person give me his or her undivided attention during our meetings? Will this person take phone calls or office interruptions while we were meeting? I always had a very strict rule. I never did that. And when I was a lawyer's client, when that would happen to me, it would really irk me. I get some things, your kids, got a flat tire. I mean, some things can't be helped. Somebody's ill, going to the hospital, but just a client, the secretary coming in, with something, or so-and-so's on line 2, if you got a minute. Well, I don't at that moment. My moment is paying attention to the client, but I didn't have that problem because that was instructed away. Where will my matter fall into this person's work priorities? Will this person meet me at my home or other location? Or will he or she only meet me at his or her office? I loved meeting clients in their offices and homes, far more than in my office. They're more comfortable there. There are often documents that are there that they wouldn't bring to the office. They're uncomfortable in the law office. So it goes there. Will this person be timely and prompt? If eating a meal together, will this person charge me during the time that we were eating? I decided many, many years ago, when actually, because we talked a deal all the way through lunch, I billed for that hour. And I got more pushback on that. I decided, you know what, this just isn't worth it. This juice, as the best boss I ever had, Vern Snyder, used to say, this juice isn't worth the squeeze. Is the juice worth the squeeze? And the answer in that case was no. How will this person handle soft office costs? Copies, faxes, long distance, right? We don't even have that anymore. But back in the old days, we did. In many law firms, the most profitable partner was the copy machine, literally. And I quit billing for that stuff just because you have to have a counter, and and clients don't like it. They don't care what you charge them per page. You can charge the actual paper cost and they're still going to complain. So it's just not worth, again, is that juice worth the squeeze? And in my estimation, it was not. Does this person have a gatekeeper? Will I talk to this person, or will I have to deal with others in the firm? If so, who else may I have to deal with? It's always a good idea in those kind of meetings to introduce new clients to those people. Now let's move on to what I call the book nook. And I have several books that I wanted to, in a previous episode of the Cajun Counselor. This is a book that's it's fairly new. Money Isn't Everything, It's money isn't everything. Everything is money. A personalized approach to valuing and trading time, energy, relationships, and money. And that's what the book looks like. It's a very very good book in the personal finance area, and it's clear. They have quite a bit of discussion of money types, which is a very big deal. The second book is a lady named Rochelle Khanna, and her book is Inherited Trauma and Family Wealth, a guide to heal your relationships and build a lasting legacy. And Rochelle has written a very, very interesting book, and what she talks about, and I'll share a little bit from the back cover. As she points out, these are generational traumas, and you can see this play out even in case law. If you look back, some families are just a lot more litigious than others. And why is that? Their generational trauma is real. And trying to help people break that, I always considered a very honorable thing. And I always try to do it, within the realm of my, professional expertise. She's a licensed social worker. Generational trauma is something that, is certainly something worth getting rid of or trying to minimize. And I highly recommend both of those books. The next book is one that I actually wrote with Steve Lineberg, the first edition of Estate Planning for Modern Families in the Tools and Techniques series. And the book is now under the very, very able and capable hands of my friend Kim Kamen and Wendy Goff. Wendy's a lawyer. I don't think Wendy and I have ever met, but I know Kim. And they have done a marvelous job with the fourth edition of this book. And they have a lot of, they have some other writers with them. But the chapters themselves are really, really, really good. I mean, they cover things from planning for divorce and blended families, polyamorous relationships, international same-sex married couples, planning for unmarried couples, single clients, transgender, assisted reproduction, special needs, racial and ethnic diversity, religious differences, diminished capacity, addiction and mental illness. So this is planning for pets, digital assets, cryonics and cloning. And the last book is a book called The Soul of Wealth, 50 Reflections on Money and Learning by Daniel Crosby. And as he says on the back cover, we find ourselves at a crossroads. We all know that true wealth is far more than money, about far more than money. Wealth is friends, family, health, a vocation, command of your time, leisure, and whatever else is important to you. And yet, we are all guilty of acting as if money alone is wealth and an end in itself. How do we navigate these crossroads to find the right balance between monetary wealth and true soulful wealth? Amen. I love questions like that. Our guide is Daniel Crosby, author of the Behavioral Finance Smash Hits, The Laws of Wealth, and The Behavioral Investor. And these are 50 short essays, and it's a very, very, very good book. Now, as we close in on the finale, I wanted to end with a couple of quotes. I collect quotes, and I collect quote books, and I always start webinars with, originally it was a quote of the day, now I never get away with less than 2 or 3. Albert Einstein, everything should be made simple as possible, but not one bit simpler. A Spanish proverb, a lot of people should listen to this one. Drink nothing without seeing it poured, If you're a pope, that was a really good idea, or a king. Sign nothing without reading it. Yes. Sir Winston Churchill. It is a good thing for an uneducated man to read books of quotations. I agree with that, even for educated people. Henry David Thoreau. Our life is frittered away by detail. Simplify, simplify. Margaret Mitchell, who wrote Gone with the Wind, one of the lines in the book is, and on the movie, death and taxes and childbirth. There's never a convenient time for any of them. Ben Franklin, drive thy business, or it will drive thee. J. Paul Getty, the meek shall inherit the earth, but not the mineral rights. Lewis Mumford in The Brown Decades. Every generation revolts against its fathers and makes friends with its grandfathers. And that is absolutely true. Henry David Thoreau, to inherit property is not to be born, it is to be stillborn, rather. Now, I don't necessarily buy that. I believe that you can be very virtuous and I mean, if Marcus Aurelius can pull that off, anybody can. The emperor, the guy who could do anything, could kill everybody until the Praetorian Guard got him. But in his case, he died naturally out on campaign in Gaul in the year 180. Sarah Levan, one of my mentors was the late great Jerry Levan, and I loved Sarah. Sarah had this toast that she would give at weddings, and I will either give this toast or I will I'll read my other toast right after it. But here's Sarah's, and it's always a good one at a rehearsal dinner, that kind of thing. May your marriage be like two porcupines nestling down for the night, close enough for warmth, but not too close to prick each other. Mine, may you always have balance between personal and business life. I wish you Aristotle's mean. And I am going to, on that note, close. I wish each of you all the best that 2026 has to offer. And as the Cajun Counselor says when we're done, au revoir. And that's a wrap. Hope you enjoyed this episode of the Cajun Counselor. This is Paul Hood saying laissez le bon temps rouler. Au revoir.